Good afternoon, everyone. It's nice to see faces here this afternoon. I understand there was a wonderful workshop yesterday all day with about 85 or so participants here in the room. And I saw a wonderful little press announcement on one of our local television stations last night. Jason Peterson covered the event and did a little overview. We're pleased to get that good press coverage. But it's delightful to have you all here today at the Arkansas State Library. We are delighted to be partnering with our folks at UALR in providing this opportunity to bring this workshop to you. I'm Carolyn Ashcraft. I'm the director of the Arkansas State Library, which is where you are today. And I'd like to just welcome you here to the facility. They're going to take you through the afternoon. We'll have a break after a while, and we have refreshments and things in the back for you. Quick housekeeping note, the restrooms are immediately out these doors and right here behind the meeting room, basically. If you have cell phones, if you'd set them to vibrate if they're not already turned off. I have the delight this afternoon of introducing the presenter for the afternoon. Janet Gongola is the Patent Reform Coordinator at the U.S. Patent and Trademark Office in Alexandria, Virginia. I have her bio here, and I'm going to share a little bit about her, because we just met briefly about an hour or two ago. But it says here that she is, in her capacity, that she manages all aspects of the agency's implementation of the America Invents Act. I understand she is very busy. She has racked up frequent flyer miles all over the country because she is requested quite often to come do presentations on the America Invents Act. She has been an associate solicitor in the Office of the Solicitor at the USPTO, where she provided legal advice to the agency officials and defended the decisions of the Board of Patent Appeals and Interferences and the Trademark Trial and Appeal Board before the U.S. Court of Appeals for the Federal Circuit. She has, of course, a Juris Doctorate degree from Indiana University School of Law in Indianapolis. And she has BS degrees in chemistry and mathematics. It was interesting, the thing that I found interesting about her was that her bachelor's degrees are from Muskingum University, which I had never heard of. So I Googled it to find out a little bit about the university, and I found out it's in New Concord, Ohio, sort of between Columbus and Pittsburgh, it looked like, on the interstate. The other interesting thing that I found out about that university were some of the other celebrated alumni, and she probably knows all of this, but it was interesting to me to find out that John Glenn, U.S. astronaut and former U.S. Senator, graduated from there. Jack Hanna, whom I see quite often on the David Letterman show at night with his animals, naturalist and adventurer and zoo aficionado, is a graduate of Muskingum. And one of my favorite actresses, if you're under the age of 40, you may not know her, Agnes Moorehead, who played the mother of Elizabeth Montgomery in Bewitched. Anybody remember her? So I thought it was interesting. You have some great alumni there from your university. We are delighted to have you here for your very first official visit to Arkansas. And if you would allow me to present to you a little publication to take back with you. This is Picture Arkansas, which is a publication from the Arkansas Department of Parks and Tourism, which will show you all the wonderful things that we have here in our state, so that hopefully it will entice you to come back, Janet, and spend some more time with us besides just doing presentations. So welcome to Janet.
Well, thank you for that very kind introduction. That's probably one of the nicest introductions I've received on a personal level. You took some time to get to know me a little bit. And that's exactly what I found so far, hospitality throughout the state since my arrival last evening and throughout this morning. So I'm thrilled to be here with you today, and I hope you enjoy our discussion of the America Invents Act. I truly do want it to be a discussion, so at any point in time, if you have a question or a commentary about anything that I'm talking about, please feel free, raise your hand. A microphone will be around to you, because it's your time to get to know the Act, and I want to make sure that all of your questions are answered during our next 2 hours together. Now, you probably all know that our Constitution in the United States contains what I call an intellectual property clause. In Article 1, Section 8, Clause 8, our founding fathers included the words that this country is to promote the progress of science and the useful arts. Now, what you may not know, though, is that no other country in the world contains a similar intellectual property clause in their constitution. So this is much to the credit of Edmund Randolph, Thomas Jefferson, James Madison, for thinking and having the foresight to include such language in our country from its inception. Now, if you think about it, though, in technology in 1780s, when the Constitution was ratified, was the power loom, steam engine, turbine engines. Look at where we've come today. Technology now is web casting, blogging, icons on your little computer apps that you have on your iPhones. So we've come a long way in 300, 200 some years since the Constitution. And I think that's what President Obama was attempting to capture in his January State of the Union address, when he said then that technology is what this country has always been about. And I agree with that, and indeed the statistics will show you that to be the case. Please, the next slide. So the Patent Office has done a study earlier this year in conjunction with the Department of Commerce to investigate the role that intellectual property plays in our society. And the slide shows you the data. 40 million American jobs are tied to intellectual property. 5 trillion of the gross domestic product is based on intellectual property heavy industries. Wages in intellectual property industries are 42% higher than in non-intellectual property industries. And then lastly, 775 billion of all of our exports come from IP-intensive industries. So with that framework, next slide, President Obama went on to pass and sign into law the America Invents Act last September 16th. Now, in doing so, he had certain objectives in mind. And those objectives are what are captured in his quotation featured on the slide. His goal was to reduce the backlog of unexamined patent applications sitting on the Patent Office shelves. And our backlog currently stands at 630,000 unexamined patent applications. He likewise wanted to foster innovation in the United States, build our economy, and create jobs. And he is resting on the different provisions in the America Invents Act to help achieve these attributes. Next slide, please. Okay, so now let's take the America Invents Act and start to give this amorphous provision some bones. What the America Invents Act contains are 3 categories of provisions. Some that require new rules to be created, others that require programs for the Patent Office to establish to help all of you file patent applications, navigate the Patent Office waters, and secure patents. And then lastly, Congress asked the Patent Office, along with a few other governmental agencies, to conduct certain studies into various areas of intellectual property law, thinking that down the line, perhaps we'll make some new laws in these other areas. But first, Congress needs to have a background and some framework to know where the landscape lies. Okay, so now those are the 3 categories. That's the first column on the slide. And what I've done for you is broken down how the Patent Office is doing in terms of our implementation. There are 20 new provisions of law for which we must make rules. And so far, there are 16 that must be done by that 1-year anniversary, and 4 that have to be done within the 18-month anniversary. We have 7 new studies to conduct. 3 of them have to be done by the anniversary, and then 4 in the years to come. And then finally, programs. We have 4 to set up in total, 1 by the 1-year anniversary, and the remaining ones down the line. Or I'm sorry, 3 by the anniversary, 1 in the time period thereafter. And we're going to talk about, in detail, all of these different rulemakings, studies, and programs so you understand how they fit together to spur innovation, spur the economy, and spur job creation. Next slide, please. Okay, so I've been studying the provisions in the America Invents Act for roughly 9 months. That's all I do. 8 hours a day, plus some. I won't tell you how much the plus some. On airplanes, wherever I am. I spend all my time spending on the America Invents Act. And I have identified 3 attributes that I take from these provisions. And I show them on the slide. I believe that the provisions, first, are going to give greater certainty in patent rights earlier in the patenting process. Second, there are provisions that are going to prevent what I call low-quality patents from ever issuing, or ones that do mistakenly issue, help them be removed from the patent system. And then lastly, there are provisions that will build what I call a 21st century patent system, meaning provisions that will help the Patent Office hire the number of examiners that we need to tackle that 630-some-thousand backlog of unexamined applications, modernize our IT systems so that we are equipped to do rapid examinations of patent applications. So we'll talk about how all of the provisions fit into one of these categories. And the reality is that most provisions bridge across more than one of the categories, but for purposes of example today, I'll put them into one of the categories for you. Next slide, please. Now you'll know what category the provision fits into because I've color-coded them. In the top of the slide, in the topic bar, I've indicated purple for faster assurance in the patent right, green, remove or prevent bad quality patents, and then lastly, blue for building the 21st century patent system. Okay, so the first provision I want to cover with you is prioritized examination. Now this provision went into effect on September 26th of last year. So today, any one of you out there can secure a prioritized examination of your patent application. What does this mean? Well, prioritized exam allows you to get a quick turnaround on your examination in exchange for you meeting minimal requirements. First, you have to pay a fee. The fee is $4,800 if you're a large size entity, $2,400 if you're a small size entity. And we're working on, which I'll talk about later, reducing those fees even lower. Second, you have to have an application that's of a relatively small size, meaning that you can't have more than 3 independent claims, 30 total claims. Claims are the property boundaries that you use to define your intellectual property, the property right, the fence around your property. If an application is too big, we won't be able to turn it around. If it has too many claims, we won't be able to turn it around in short order. And then lastly, you must file your application electronically if it is a utility style application. There are 3 kinds of applications: utility, plant, and design. Utility applications are directed to functionality, the projection system, a cell phone, a chair. That's the type of functionality I'm talking about. So if it's a utility application, you must file it electronically because it enables us to move the application easier through our patent system. We don't have to convert from paper to electronic form before we begin the examination. Now, what are some stats to show you how well this program is working? Well, that's the last bullet on the slide. So far, since September 26th of last year, we've had little less than 5,000 applications for prioritized exam. 96% of all of those applications met the eligibility requirements, fee, size, electronic filing. Of those, almost 40% were filed by small businesses. And then from there, so far, we've issued little over 600 patents within a time period of 5 months. Now, on average, it takes 3 years for the Patent Office to pick up an application to even start the examination process. And on average, it takes 3 years to get through the examination process. It's a total of 6 years. Through prioritized examination, in 5 months, you are getting a decision on the patentability of your invention through this program. So by far, this is, if you need fast turnaround on your application, you want a quick decision on patentability, prioritized examination is a program that I would strongly encourage you to consider using. The agency is statutorily capped to accepting no more than 10,000 cases for prioritized examination in a given year. Congress placed that cap on the agency so that we can focus partially on prioritized cases, but also on that 630,000 backlog of unexamined applications. We can't spend all our time doing fast type track cases. And also I should mention, once you get into this prioritized exam, it's identical to regular examination. There are no differences. It's just that the applications will be placed on an examiner's special amended docket. And by being on the amended docket, that means the examiner picks up those cases before the ones on their regular docket. That's how we achieve the fast turnaround. But the examination process itself is no different than regular exam. The agency also has a different type of accelerated exam program. It's called accelerated exam. Some of you may be familiar with it. It's been around for 3-4 years now. I would encourage you to use prioritized exam over accelerated exam because accelerated exam has one key drawback. You have to conduct a prior art search and you have to produce the results of that search with an explanation as to the relevancy of your search hits. The prior art that you identify, you've got to explain to the Patent Office how that art bears upon the patentability of your invention. Now, many people don't like to put those statements on the record because it is creating what we call a prosecution history about what you're saying your invention covers, does not cover, how it's different over the art, how it's the same as the art. In the prioritized program, you do not have to conduct a search and you do not have to explain the relevance of the references. So for you, it is a better safeguard in not creating prosecution history estoppel. And price-wise, accelerated exam, in terms of the fees you pay to the Patent Office, it is a little cheaper. However, you're going to have to pay for the search, pay an attorney, or you spend your time preparing the statements of relevance. That's a cost that folks have told me is far going to exceed $4,800 or $2,400. So in the end, financially, prioritized exam is the way to go. Next slide. Okay, first inventor to file. Now this provision is probably considered the hallmark of the America Invents Act. Anybody who hears about the America Invents Act in one breath will hear first inventor to file in the next breath. So what the agency has done is we are in the process of implementing this provision through some proposed rules and some proposed guidance. The provision does not go into effect until March 16th of 2013, 18 months from when the President signed the America Invents Act into law. So in proposing rules and proposing examination guidance, we want to hear from all of you as to whether you like our proposals, if you think we are implementing this statutory provision correctly. And you will have a chance, I'll talk about it, to give us feedback, and eventually we'll take that feedback into consideration and issue final rules. So what I talk about for first inventor to file is in the proposed phase at this point. I want you to know we're still flexible. We still have chances to modify, short of where the statute dictates what behavior we will have to do. Okay, so now what conceptually is the first inventor to file provision? Well, what it means is that priority to an invention or a patent will be granted to the first inventor to file a patent application in the U.S. Patent and Trademark Office. Now, contrast that with our system today. Today, priority of an invention is given to the first to invent the invention, regardless when they file their patent application. Okay? And next slide, please. I want to do a little hypo to bring this message home for you so you understand exactly what we mean conceptually when we say first inventor to file. Okay, so if we look at our little fact pattern, we have A inventing in March, B invents in April, B files a patent application in May, and A files a patent application in June. So today, under the first to invent, regardless of filing, we could see that A invented first, A would likely get the patent. And I say probably here, I put those lawyer wiggle words in because there likely would be a complicated procedure called an interference proceeding involved in this fact pattern. And there'll have to be some proofs, and the inventor is going to have to document and prove up their invention. But all else being equal, A will probably get the patent. First to invent, A gets the patent. Going forward, under our first inventor to file system, well, B invented, and B is the first inventor to file, so B will secure the patent. Does this help you see the difference between what we have today, which I call pre-AIA, and what we'll have starting March 16th of next year? Are we good on that hypo? Okay, then let's move forward. Okay, so now that we have the concept in mind, I want to talk about what the first inventor to file provision does in terms of prior art. Okay, prior art are all types of disclosures that precede your invention. They could be patents, patent applications, journal articles, sales that are made in the public domain, uses that are visible to the public, or future types of public disclosure media that we don't even know about today. But any type of disclosure that precedes your patent application, your invention, is what we call prior art. So the first inventor to file provision simplifies prior art and makes our prior art system more in line with other industrialized countries. And now we'll talk about how it does that. Okay, first of all, the first inventor to file provision retains the U.S. grace period. What do I mean by a grace period? Well, from the date that the inventor discloses his invention through one of those means, patent application, sale, the inventor has 12 months, 365 days to file their application. And if they do, within that time period, that disclosure will not be treated as prior art as to their invention. So it won't defeat the novelty or newness of their invention. It won't render their invention obvious. But if they wait 366 days, 390 days, 400 days, then their disclosure will be prior art that could defeat the newness or render obvious their invention. So both systems retain this grace period, which is advantageous for inventors because in that 1 year period, they can make prototypes, they can try to sell their prototypes, they can start commercializing their invention, they can seek venture capital. So it's fostering innovation, fostering economic growth. Now, next on the list is specifics about certain types of prior art. I told you that uses and sales, if done in the public, are prior art. Well, under our first to invent system, today we only count uses and sales as art if they happen in the United States. Going forward, under first inventor to file, uses and sales will count anywhere in the world. So that use over in China could now be treated as prior art against your invention. The reason we're dropping the geographic restriction to the United States is because we're moving towards harmonization. We're a global marketplace now. We're not just a US marketplace. Similarly, for a patent or a patent application publication, we treat those types of documents as prior art on what we call their earliest effective filing date. What does that mean? Well, earliest effective filing date means the date you filed the application, or the date that that application, what we call it tracing priority, or seeks the benefit of an earlier application. So it's the actual filing date or the priority date to which the application traces back. Now, in our current system of first to invent, the effective filing date is the actual filing date or the earliest U.S. priority date. U.S. priority date. Going forward, under first inventor to file, we're harmonizing with the rest of the world. We're becoming global. So we're going to treat the effective filing date as the actual filing date or the earliest foreign or U.S. filing date to which priority is sought. So the bottom line of what this means is that patents and patent application publications will become art potentially sooner in time than they are today because we're recognizing those earlier foreign filed priority type documents. That's the bottom line for all of us. But in doing so, we're harmonizing with the way the rest of the world treats patents and patent application publications as prior art. Next slide, please. Okay, now this is what the statute says. It says, okay, we're going to define prior art for you. And we've got two categories of prior art, what I list for you on this slide and what's on the next slide. So you're going to make your disclosure, your patent application filing, and we're going to look back in time and see what's back there. And what we can look to is governed by what I put in the third column here. First row, third column, 102A1. We're going to say anything publicly disclosed before your invention is going to be prior art, and those types of public disclosures are the bullets: patents, printed publications, sales, uses, or anything else that the world eventually develops. We already talked about that. You know that. Now, Congress is going to say, though, if certain of that activity occurs in the grace period that we talked about, yes, it's prior art, but we're going to statutorily accept it out. So we're going to cut you a break to allow you time to commercialize, make prototypes, etc. during this 1 year. So 102B1 sets forth the exceptions to what we call 102A1 prior art. And the two bullets in the third column lay out the exceptions for you. And I'll tell you in my speak what they are. Okay, in that 1 year, anything done by the inventor. So if the inventor made a patent application, if the inventor made a sale, if the inventor made a public disclosure of some sort, that's going to be accepted out as prior art. It's a little broader than that, though. It's anything the inventor did, a joint inventor, or someone that the inventor authorized to make the disclosure. Now, I'm going to lump those categories as three entities together, and I'm just going to say the inventor for shorthand speak. But really, consumed within that term inventor, I mean three different people: the actual inventor, a joint inventor, or someone affiliated with the inventor who the inventor authorized to make the disclosure. Okay, so that's the first exception. So what the inventor does within that 1 year, we're not going to count. Now, what if a third party comes along and does something in that 1 year? Well, depending on what the inventor does, we could discount what that third party does. And we can discount it where if the inventor, before the third party, made the same type of disclosure. meaning they disclose the same subject matter as the inventor. If the inventor already put it out there, and we said the inventor's disclosure, if done during the grace period, doesn't count, why should the third parties? So we're going to nullify that out as prior art. Now, let's go to the next slide, and I have an example to show you these two exceptions to prior art to kind of bring this home a little bit more. Okay, so example 2, we have A inventing in April, then A's grace period, April 2013. Then A's grace period starts in July 2013 and runs for a year, and just after that year, A files their patent application. But during the grace period, A publishes their application. Now, technically, that publication constitutes prior art. It's a disclosure of the invention before the application filing. But under our 102B1 exception, because the inventor made that disclosure during the grace period, we're going to knock it out and pretend it didn't exist in terms of prior art. So there's nothing that's going to come in time before the inventor to destroy the novelty or render the inventor's invention obvious. So under this fact pattern, the inventor is free and clear of the prior art by virtue of the exception knocking out the inventor's disclosure. Okay, so everything we know, all other conditions for patentability, A should get the patent. Okay? Yes, sir?
I have a question about disclosure. I've had a big arguments in the past. About disclosure. I've had big arguments in the past with people that I worked for and things like that because they wanted me to present something to a group of people from outside, and I said, fine, you give me some NDAs and I'll do it. But they say, oh, you're insulting these people. We don't trust them. I said, you don't understand, So what is your take on this about NDAs and so forth? Disclosure.
So I think you have a right to be concerned because when you're making public discussion of your invention, and by public, I don't mean you're giving a speech like in this room to a group of people about your invention. You're disclosing your invention outside your company, outside your laboratory. That could be a public disclosure. And if in the right circumstances, that public disclosure can be novelty defeating to your invention, because if you've put it out there and you wait more than 365 days to file, that disclosure could be used to prevent you from getting a patent. Now, if the disclosure is made under a confidentiality agreement, another word for that is a non-disclosure agreement, then it's the same as though you're disclosing it within your company and you're protecting yourself from creating potentially invalidating art. So you do have to be very careful with making these public to outside your company. Yeah, you do. Do you have other questions? Now you just stop me at any point if you have a question.
In the case that this gentleman just made, if he discloses, but let's say 6 months later they file for utility patent, then he's fine.
Yes, he would be fine. If that disclosure was done within the grace period, technically it's art, but then the exception comes along, nullifies it out. Yeah. Okay, next slide. Okay, now we're going to go to the other exception. So it's the same facts, except we introduce B. And now B invents after A, and B publishes after A, but B publishes during A's grace period. Okay, so under 102B1 exception, because A has published before B, A can nullify out B's publication, remove it as prior art. One condition. What A disclosed, well, two conditions. If what A disclosed in the publication is the same invention that A files, that's condition 1. And condition 2 is what A disclosed in A's publication has to be the same as what B disclosed in B's publication in terms of the invention. And if that's the case, then B is going to be wiped out. But if B is disclosing here something that would be different, perhaps an obvious variant of what A has disclosed and subsequently files, then B would not be wiped out as prior art, B would remain as prior art and potentially render A's later filing obvious, preventing a patent from issuing. This concept about what I call the identicality between A's publication and B's publication is part of the Patent Office's proposed examination guidelines. The statute uses the words "the subject matter" when referring to what A and B disclose, leading the Patent Office to infer that it has to be the same subject matter. But we are interested in your commentary on that issue. Specifically, do you think, the question would be, whether an obvious variant that B discloses should be permitted to be nullified out as potential prior art, as well as if it's the same thing? So that's an issue that we're wrestling with. We're seeking comment. Stay tuned for more information. But I hope that you can see in this example, if it's the same, A is going to wipe out B, A should get their patent. B won't be art as to A. We good?
I guess my question is, why doesn't the language just state that it, it has to be the same?
The question is, why didn't Congress just state whether the identicality had to be the same, or could an obvious variant count? I think this is a situation where Congress was making so many provisions all at the same time that this little nuance didn't dawn on them. Some people might say they did. They said the subject matter. They meant the same. And other people would say, well, no, they said the subject matter, but what they were really trying to get at was a little zone of protection around the subject matter. Folks are talking about a possible technical correction to address the statutory language and make it clear exactly what Congress intended. The Patent Office has looked into what we call the legislative history, the reports that Congress prepared, the floor statements, and there doesn't seem to be anything in there that really answers the question, one way or the other. Yes, sir.
But if B publishes it's an obvious variance on what A is publishing, why wouldn't it be nullified by the fact that it's an obvious variance?
Well, what will happen in that situation is the exception won't apply. So then B's publication could be art as to A, preventing A from getting a patent, but it's a double whammy. A published before B, so then A's publication will come along and probably render obvious what B did. So in this fact pattern, probably no one is going to get the patent. That's how it'll end up shaking out. Okay, next slide. All right, now we have more prior art. So now we go to 102A2 and 102B2 for the exceptions. So what 102A2 says, that if somebody filed, in my speak, somebody filed a patent application before you, or they actually patented it before you, or they filed what is called a WIPO publication, an application filed under the Patent Cooperation Treaty. So in short, if someone tried to patent it before you, their attempt to patent will qualify as prior art against you and prevent you from getting your patent. But then we come along and Congress has created an exception for us in 102B2 to these filings that were made under 102B1, these applications, WIPO, et cetera. And basically they say that if this, we're back to the grace period, if this third party made their filing, if it's yours, if you made the filing during your grace period, we're going to accept that out as prior art. Or if you made the filing, third party makes the filing, and the subject matter is the same, we're going to wipe that third party's out. It's very similar to what you saw with the last set of prior art and exceptions. So let's look at our hypos here, and I think it'll become clear what I mean. So here we have the A and the B. A invents, B invents. Then during A's grace period, B files a patent application. And then A files a patent application. Okay, in this fact pattern, B has filed a patent application before A has filed the patent application. So B's application is prior art to A that will prevent A from getting the patent. What's going to happen here is B will likely get the patent. So this is the 102B1 prior art creation. Okay? Now let's go to the next slide, please. Okay, now we're going to see the exception to this. Okay, so we have similar facts. A invents, B invents, A publishes, B files a patent application, and then A files the patent application. So now we've introduced A's publication into the mix. And so from what we talked about earlier, as long as what A publishes is identical, the same subject matter, as what B files in B's patent application, A is going to wipe out B's publication as prior art, nullify it out. So A should be able to get its patent. Does that make sense? It's the same theme, it's just what is the disclosure that we're looking at is different. And then the concept of this identicality, which we know is still up in the air a little. Yes, sir?
If you have a subcontractor or a consultant, is that considered publishing?
So,
I mean, you're disclosing that information to them,
oh, if you disclose to your subcontractor,
right? A consultant?
is the subcontractor considered like your employee? I would take it to,
I would say so.
I
yeah.
would say so. So probably it's still within the same inventive entity,
Okay.
more than likely. I would, if it was me, I wouldn't disclose to anyone without having a non-disclosure agreement. That's the gentleman's point up here. You're better off to have a non-disclosure agreement rather than rely on the law. You can control it, so it's better off if you do that. Okay, next slide. All right, so what happens, and this is a proposed rule, what happens if the patent office makes a rejection, but you know that what they're rejecting over was either your own disclosure or that you disclosed before that third-party disclosure? So in other words, one of the exceptions should be triggered. What do you do? Well, the Patent Office has created a proposed rule that says you can file an affidavit or declaration with the Patent Office saying, hey, patent examiner, you made a mistake here. What the art that you're relying upon really falls into an exception. It's either my own work or it's work that I'm able to nullify out. So it shouldn't apply to me. So take it away as prior art. That's all. And so what should happen then, the examiner reads your affidavit declaration, either agrees or disagrees, and then will remove the rejection. So the patent examiner, if it's your own disclosure, they're probably going to catch it. But if it's a disclosure that you authorized someone else to make, it's going to be made in that other person's name. So the Patent Office isn't going to know, hey, you have this agreement to authorize that disclosure. This shouldn't really be art. So you're going to have to tell the Patent Office. So we provided a mechanism for that to happen so we don't apply the wrong prior art against you. Okay, next slide. Now, when does the first inventor to file provisions apply, and when does the first to invent provisions apply? So old law versus new law. In short, the new law will apply to any application that you file after March 16th that traces priority only into March 16th. You never go back in time. So if it's a brand new patent application filing, you're not seeking a claim of priority backwards. All of the new law, the new scheme for prior art, will apply to that patent application. That's what this slide says. Next slide. Okay. Now, when are you going to be in the situation of having both the old law and the new law applying? Well, if you file a continuation in part application, that's one, or two, you have a claim in your application that tries to get priority back to before March 16th of 2013. In those two situations, then, you're going to be subject to new 102A, 102B that we talked about, as well as the old 102G, which involves you being the first to invent. Okay, so my advice to you is after March 16th of next year, you want to keep yourself squarely within one system or the other system. You don't want to be bridging the two systems. It makes it too confusing to keep track of what's art for you and for the examiner. So my advice is do not file continuations in part after March 16th, and then you either file your application today, keeping yourself squarely within the old law, or you wait till after March 16th and file your invention then, taking yourself into the new law. But do not bridge. Okay. Oh, yes, sir.
When you say a new claim, do you mean even if there's no new matter?
I just
Or
mean,
only in the case of new matter, you're
well, when I mean, if you have a new invention, you have a choice. You can file it today, or you can wait and file it after March 16th.
Right.
So you have to pick one of those two. I'm not getting into the concept of new matter at all. If you introduce new matter into your invention and you've claimed it, then you'll be in a CIP type situation, and then you're going to bridge both worlds and have to.
That's my question.
Yeah.
If you're, what you said, if you change a claim or you do a CIP afterwards, so by changing a claim, you mean even if there's no new matter in the claim?
If you have a claim, even one, that you trace priority back to the old law, then that whole application will be subject to new 102, new 103, A and B, and old 102G. A single claim. So you have to keep your application squarely within one regime or the other regime. You don't want to have mixed priority claims within an application. Does that?
Just by revising a claim in prosecution, you don't
Not
automatically-
amending, if
All right.
not amending a claim. No,
Yeah.
oh, I'm sorry, I didn't quite understand that. No, not by amending a claim you won't introduce. It's if you have mixed priorities.
Yes.
Some you file strictly in the new, some you file in the new, but you're saying, hey, I get the benefit of my old date. I'm tracing priority to a provisional or a PCT that was filed in the old. Then you have a mixed priority claim in your new application, subjecting you to the Charles Dickens land. Best of times, worst of times.
That's
Is
why I
that-
was confused. You
oh.
said new claim, and I,
Okay, I'm sorry. I didn't mean to.
These publishing exceptions, I would not have predicted that a lot of the law would have relied on that. The Europeans, are they using publishing exceptions? In other words, are they using the fact that one has published, are they using those as exception, or is the first to file strictly that first
In
to
Europe,
file?
it is a true first to file. They
Right.
don't care about inventorship.
Right. I mean, it would seem to me that that's what we would be going for, as opposed to, I mean, this really doesn't change a whole lot. I mean, it's still a matter of who published first.
So some have described the first inventor to file system as a first to publish type system. In a way it is, because you can see if you publish before another third party, you can wipe away their publication. So in that sense, you might see it as first to publish. The problem with that is that first publication had better be a patent application, a provisional, because if it is anything other than that, you will destroy the novelty of your invention in the rest of the world, and you will not be able to get a patent anywhere but the United States.
Is there a reason why we didn't just go to a first to file, period?
I don't know the rationale for not going straight first to file. Some say that in effect the United States is a first to file system today, regardless what we call it. And the reason for that is because in interference proceedings, which are designed to hash out who invented first, in the last 7 years there's only been one case where the entity that did not file first prevailed and secured the patent. So in all those other instances, it was the first to file actually got the patent. So you might liken us to a first to file system already. People like the grace period, and I suspect that's why we did not go to a pure race to the patent office, whoever gets there first, regardless if you're an inventor or not.
That certainly would make things a lot simpler.
On its face, yes, because you just see who gets to the patent office first. In terms of trying to spur innovation, the concept of offering the grace period gives an inventor some flexibility to see, do they have something worth pursuing? So they have a year to disclose it. See, does anybody going to bite in this big market pond on that invention? And then make the patenting decision. So people like the grace period. I suspect that's why. Okay, any other questions? Okay, let's move on. Oh. Okay. Now, oh, I'm sorry. Could you go back? I didn't realize you moved on. Okay. So what this slide is saying to you is, okay, we, the Patent Office, need to know what system you're under. Are you under the old system? Are you under the new system? Are you under both systems? So we're proposing a rule that would require you, the patent applicant, to tell us which system you're under so that we will know what prior art to apply, the prior art of the first to invent or the prior art of the first inventor to file. That's what the slide says to you. But when you do that, you don't have to identify with specificity, oh, this claim is old, this claim's new, this claim's mixed priority. You simply have to make the statement, my application should be examined under the old first to invent law, the new first inventor to file law, or both regimes. You just tell us. That puts the onus on you. It would be very difficult for the Patent Office to have to sort through claim by claim, trying to trace priority for you to figure out which system you're under. You are in better position to have that information, so that's why we are proposing that you tell us, and then we'll do according to what you tell us. Okay, next slide, please. Okay, supplemental examination. We'll do this one and then we'll take our break. I realize it's after lunch and you probably need some energy, and I think some cookies will be arriving. Okay, so what supplemental examination does is it offers to a patent owner a means to have their patent re-examined by the Patent Office on the basis of an item of information. Now, this item of information has to be a patent or a patent application, some type of printed publication. Now, the reason the patent owner might want to do this is because this item of information they didn't know about during original examination, and they want to make sure that their invention is still patentable over that item of information. Next slide. But the bigger benefit is the patent that's re-examined will be immunized from an inequitable conduct attack in a subsequent litigation on that item of information. So what inequitable conduct is you're a patent owner, you sue somebody for infringement. That accused infringer will come back and say, your patent is unenforceable as to every single one of the claims because you, patent owner, engaged in some form of inequitable conduct when you were prosecuting that patent application before the Patent Office. And that means if that is proven, if your inequitable conduct is proven up, then you can never enforce that patent. It will essentially be dead to you. Now, what could be this inequitable conduct? Typically, it's that the patent applicant withheld a reference because they didn't want the patent examiner to see the reference because it would show that their invention was not, or was anticipated or obvious. Or maybe they misrepresented what the reference was about. This supplemental examination is a mechanism for a patent owner to correct that bad behavior. They can say, whoops, there might have been some funny business going on. I want to correct it, so I'm going to bring my patent in for a supplemental examination. Next slide, please. Okay, now what will happen is the Patent Office, upon receiving a request for supplemental exam, will decide, does the item of information raise some type of substantial new question of patentability? And it could be any question of patentability. It could range from, is the patent subject matter eligible to be patented, to whether there was a written description made of the invention, to whether the invention is obvious over this prior art reference. The Patent Office has 3 months to decide, and if there is no substantial new question, the Patent Office will issue a certificate. And at that point, the inequitable conduct immunization attaches. That's the ideal for the patent owner. But if there is a substantial new question, the Patent Office will re-examine that patent. Next slide, please. So this gives you a visual depiction of the supplemental examination process. Patent owner requests, 3 months, the Patent Office makes a determination as to whether there is a substantial new question. If no, supplemental exam is done, we get a certificate. If yes, then ex parte reexamination will follow. And ex parte reexamination is available today. It's a means to get a patent reexamined. A third party or the patent owner can take advantage of it. Ex parte reexam is based upon only patents and printed publications, normally. But if the ex parte reexamination happens through the supplemental examination route, any of the grounds of patentability can be considered during the reexamination. Next slide. Okay, now the Patent Office proposed rules for how supplemental examination is going to work, apart from that basic framework. We suggested that, look, as a patent owner, you should only be able to introduce to us 10 items of information, because we only have 3 months to make the determination, so you can't send box loads of information to the office, or we'll never get done in 3 months. But you can request as many supplementals as you would like in parallel, each, though, would be limited to 10 items of information. Now, we heard from all of you, and the public did not like this 10-item limit. So next Monday, we're going to publish our final rules. So I'm sorry I can't talk about all the details of the final rules today because they're not available to the general public yet. But we have heard your suggestion that 10 items is too restrictive, and you will see an increase in the number of items when our final rules come out next Monday. Next slide. Okay, now, in our proposed rules, we suggested that you provide us with a slew of information about the documents that you're submitting. We wanted a mapping to show exactly how the item bared upon each patent claim and a lot of detail. You all told us through public commentary that we were asking for way too much information that placed a heavy burden on you. So next Monday, when you see our final rules, you will see that we've lightened the burden. The content requirements for the request are going to be reduced significantly. Next slide. Okay, then a couple of final points from our proposed rules. While that 3-month supplemental exam phase is going on, you're not, as the patent owner, permitted to make any changes to your claims or to talk to the examiner. You can amend your claims and you can conduct examiner interviews if we choose to go on and have an ex parte re-exam because the standard substantial new question is met. But during the 3-month window, we just need our examiners to be focusing on deciding whether the items of information trigger the standard. And then in the end, we'll issue you a certificate for supplemental exam in electronic form. And you're not going to see any changes on these aspects for our final rules. Next slide. Now, what's supplemental exam going to cost you? It's expensive. 2 phases to it. The request for supplemental through that first phase of 3 months is about $5,200. If we order ex parte re-exam as a result, then that's going to cost you about $16,000. So taking it together, it's about close to $22,000 for a supplemental exam. Now you're probably thinking, well, what happens? You got to pay the $22,000 up front. What happens if you don't engage in the re-exam? Well, we're going to refund to you the $16,000 for the re-exam. But we require the money up front because the Patent Office doesn't want to be in the situation that we've determined there's some sort of substantial new question of patentability, suggesting there might be something wrong with your patent, and then you, the patent owner, come back and say, oh, that's okay, we don't want that supplemental after all. We don't want to expose any defects in our patent. The Patent Office would be in the situation then of having to incur the cost to take the re-examination forward. So that's why for us, we thought the better system was require full $22,000 up front and then reimburse if we don't do the re-examination. Okay, next slide. I think we'll be, well, let's do this one, then we'll be at our break. Okay, so I mentioned there were some studies that the Patent Office had to do. One of the studies asked the Patent Office to look at ways to help small business secure foreign patent protection, so patents in Germany, Asia, South America. So we researched this. We held hearings, we collected written commentary from the public, And we came up with a series of recommendations for Congress. So what we suggested that Congress do is to consider ways through diplomatic channels to talk to foreign governments to help streamline patent laws through global harmonization, and also to consider offering small entity discounts like the United States offers. On almost all filing activities, a small business in the United States gets a 50% discount. We're suggesting other countries consider giving a similar discount. We also recommended that Congress, through the Small Business Administration perhaps, figure out ways to educate small businesses on the importance of securing global patent protection. The reason being, we're not a US-based economy anymore. We're a global economy. And a small business can help themselves in terms of the marketability of their patent portfolio if they're able to offer a patent in the United States and in several European countries and in the Asian markets. They can increase the value of their invention and their ability to get venture capital backing or someone to outright purchase their invention and make a profit off of it. But today, many small businesses don't understand, even conceptually, idea of getting a patent in another country. So we want to make sure they're educated so that they will know what options are available to them. Okay, so with that, I've gone for 1 hour. Let's take our break, and then we'll resume talking about preventing low-quality patents and the 21st Century Patent Office from after we come back.
Gongola, and so we're asked that you come on in and have a seat, and we'll continue with the second half of our program. If one of the things that we are going to try to do is to stay kind of on schedule today. Yesterday we unfortunately we ran a little bit behind schedule, which is not necessarily terrible, but we want to try to get you out more on time today. Also, we're going to ask that if you have any questions, please feel free to ask. If you see a slide or anything that you have a question about, anything that she's saying, please feel free to ask her. So we are going to go ahead and get started then.
Welcome back, everybody. Oh, I lost a few people. I'm disappointed. Okay, what we're going to talk about now is moving into the area of how to prevent or take away low-quality patents from the system. Those will be the green slides. And in light of time, I think Michael might have mentioned, I'm going to move a little bit faster now. Okay, so pre-issuance submissions is a provision that will go into effect on September 16th. What it does is allow a third party to introduce patents, printed publications, written literature into your patent application filing to show that your invention may not be patentable. But the third party is not going to be able to introduce this information in an unencumbered way. The third party is going to have to explain the relevance of the information that they are supplying. They likewise have to pay a fee. So the fee and the explanation requirement prevents harassment for you, the patent applicant. Okay, next slide. Okay, now what applications are eligible? Any pending patent application, any abandoned patent application can be subject to the submission of what we call this pre-issuance submission, some type of document. Now, the third party is not required when they make the pre-issuance submission to serve the submission on you. What will happen is if the Patent Office will notify you that there is a pre-issuance submission made in your application file if you subscribe to the e-office action. It's an electronic office action system where all communications between you and the Patent Office happen through email electronically. Okay, next slide, please. Okay, now the timing requirements are strict so that the Patent Office will get the information of potential relevance to examination as early as possible in the process. That way, the patent office makes a quick determination on patentability, and you won't waste your time if it turns out your invention is not patentable pursuing this patent. You can cut bait early on. So the timing, it's kind of confusing. The third party has to make the submission before the notice of allowance, before the earlier of the notice of allowance, or the later of 6 months after your application publishes, or the first rejection. So I'm going to do a hypo here too, because I think it will help, so next slide please, show you this timing restriction. So we have an application filed, 18 months it publishes, 24 months is the 6 month after publication date, then we have a first rejection, and then finally a notice of allowance. So, based upon the timing, we're going to do the green first. We have to pick the later of 6 months after publication or first rejection. So the later of is going to be first rejection. And then we have to pick between the green, first rejection, and the earlier of either first rejection or notice of allowance. So the earlier is the first rejection. So in this fact pattern, a third party has to submit this prior art to your application before a first rejection, or they'll never be able to make that submission. Okay, next slide. Okay, now the office is going to treat the submission as having been made on the date we receive the submission. This is going to avoid the patent office taking steps on the application, sending out an office action to you. Meanwhile, at the same time, you're sending in, the third party is sending in a pre-issuance submission. We don't want papers crossing in the mail. Next slide. Okay, now the contents of what a third party has to do. Well, they have to give us a list of whatever documents, and then they have to give us a concise description of the relevance of these documents. This is not the opportunity for the third party to participate in prosecution, but they need to explain, at least at a high enough level, why this document has some connection to the patentability of your invention. Because otherwise, the patent office, if the document is 500 pages long, we can't sort through the document trying to guess why it's being submitted. We need the third party to tell us. Next slide. Okay, next slide after that. All right, now how is the patent office going to process these? Well, first of all, the patent office is going to receive the submissions, and we're going to make sure they comply with the statutory requirements. They're filed within the time window. They contain the statement of relevance. The fee has been paid. After we check the box on the procedural requirements, we will then forward the submissions on to the examiner. If the submission is not compliant, the patent office will alert the third party to say the submission is not compliant, and will identify what the defect is in the submission. So the third party might have a chance to cure the defect. Next slide. Now an examiner, once they get the submission, will treat it exactly like they treat an information disclosure statement, which is a submission the applicant himself makes of what the applicant perceives to be the relevant prior art. So the examiner will go through the submission, look at the references, they'll initial and date the references indicating their consideration. That the applicant does not need to respond to any of the documents in this third-party submission unless requested to do so by the patent office. Okay, next slide. What's the cost? Well, a third party will have the chance to submit 3 references for free, and then for each grouping of 10 references thereafter, there's a cost of $180. So the fee is relatively low to make these submissions. Excuse me. Okay, a separate provision is called the Citation of Patent Owner Statements provision. This also goes into effect on September 16th of this year. What this provision does is allow anyone, patent owner or third party, to submit into a patent file statements that the patent owner has made about how to understand their claims. When these statements had to be made in either a court or some other PTO proceeding. The point of this provision is to make sure that the patent office understands what the patent owner thinks their claims cover. Because the patent owner might have one vision of it, and the patent office might have a different vision. So we need to understand how the patent owner envisioned what the patent owner envisioned their property rights to entail. Now, the patent office is restricted on how we are going to use these statements to apply them during an ex parte reexamination, an inter partes reexam, or one of the administrative trials that we'll get to in a little while. But we can't use the statement in deciding whether to grant one of these types of proceedings. We will only use the statements once the proceedings are underway. Now, I want to be clear, pardon me, back one slide. When the statement could be made to be eligible to come into the proceeding and be introduced. So, per our final rules, the statement could be made during an actual court proceeding or a PTO proceeding. Or the statement could have been made elsewhere, maybe in licensing negotiations, or maybe in advertisement material. But the statement was introduced through evidence in a federal court proceeding or a PTO proceeding. So there's two places that the statement could have been made to be eligible for introduction. Okay, next slide. Now, what the submitter has to do is provide the statement, provide documentation of where the statement was made. So we need corroboration. We're not just going to take a third party's word that the patent owner said that their claims covered X. We want to see a copy of that actual statement so we can verify that the patent owner did indeed represent their claims to cover X. And then there's a fee, and there has to be service in this case on the patent owner. We don't require the service for the pre-issuance submission because it's for an active application. And an applicant is expected to be monitoring the prosecution of their application. Contrast for a patent, the patent owner cannot always be expected to monitor a patent file. Patents issued, it's a piece of intellectual property. There's no ongoing proceedings before the office. So there might not be a circumstance where the patent owner would need to even look in the file to know that a submission has been made. So for the citation of patent owner statements, we are going to require service by the submitter on the patent owner. And then if the submitter happens to be the patent owner, they can try to explain away the statement. Well, when I said X, here's what I really meant, so that the patent office gets a fuller perspective. Sometimes we realize when statements are taken out of context, they can be distorted slightly from their true meaning. Okay, next slide. Now, the administrative trials, I'm going to cover these at a high level, and if you have more questions about them, you can see me afterwards, and we can go into the details. What these are proceedings before the patent office that may be a substitute to a district court litigation where the patent validity is challenged before the district court. So they're not a one-for-one substitute, but they offer an alternative venue for a third party to challenge the patentability of an invention. There's two types of trials, and I list them: post-grant review and inter partes review. And so this slide will kind of give you an overview of the attributes of those two types of trials. Places that are blue, that's points of similarity. Two types of trials have the same feature. And then the gray are points of difference. So a post-grant review and an inter partes review has to be brought by a third party. They're not going to be brought by a patent owner. And the third party must identify who the real party in interest is. Is it the person bringing the proceeding, or is it someone behind? Is it the puppet, or is it the puppeteer? We need to know who the real party in interest is that's trying to tear down this patent because of the estoppel provisions in the second column. The entity that brings one of the two types of proceedings will be estopped. Another word for that would be blocked or prevented from ever bringing a subsequent proceeding on the issues that they actually raised during the trial or that they reasonably could have raised. Now, this idea of reasonably could have raised an issue requires this third party to give lots of thought to the challenges they want to be making in the trial. Because if they don't make the challenge in the trial, they will never get the opportunity to bring the challenge ever again, in a later trial, in the district court. It's like a one-bullet theory. You're going to shoot the bullet to kill the patent once, but only once. And you have to pick when you fire that bullet, how you fire that bullet, the gun that you fire with, very, very carefully. Okay, now to trigger a post-grant review in the third column, this third party has to show that it's more likely than not at least one of the claims is unpatentable. By contrast, for an inter-parties review, the third party has to show there's a reasonable likelihood that the one claim is unpatentable. What's the difference? Well, more likely than not is a higher standard than reasonable likelihood. You know, reasonable likelihood is probably along the lines of a 50-50 shot. More likely than not, 51% chance or greater that the patent claim should go down. Now, the differences in the standard are justified because of the different bases that can be, or the subject ground, or the conditions for patentability that can be attacked. In a post-grant review, any condition for patentability can be attacked, except best mode. Contrast, in inter-parties review, only novelty and obviousness can be attacked, and then only on the basis of a patent or a printed publication. So you can't bring up sales, you can't bring up uses. So it's more restrictive in scope. Because post-grant review is broader, we're going to make it more difficult to bring. Inter-parties review, narrower in scope, easier to bring. Next slide. Okay, now timing-wise, there's also a difference. Post-grant review is available for the first 9 months after a patent grants. Inter-parties review picks up at 9 months and goes for the life of a patent. This means for you as a patent owner that at any point in time during the life of your patent, it can be subject to a challenge by a third party through an administrative trial. Just depends on what kind, either a post-grant review in the first 9 months or an inter-parties review for the life of the patent thereafter. Now, what kind of patents can be drug in? For post-grant review, only patents issued under the first inventor to file system can be subject to a post-grant review. Well, this means that a post-grant review then won't be available until after March 16th of 2013, and then it's going to take some time for that patent that's filed on that date when first inventor to file provision becomes effective for it to issue. So more than likely it's going to be 2 or 3 years before we see the first post-grant review. Inter-parties review is available for any patent application or any patent that's in force on September 16th of this year. So, inter-parties review immediately available in about a month. And then for both types of review, the Patent Office has to wrap it up within 12 months. And the point of this is important because it means that these proceedings are going to go much faster than district court litigation. To challenge the validity of a patent in a district court will vary, but it's certainly not going to be as quick as a year, except for maybe 1 or 2 district courts that I can think of. Most district courts, you're looking 3, 4, 5, 6 years. So these challenges will be swift before the Patent Office, which is a reason for third parties to come before the Patent Office instead of a district court. Additionally, because we only have 1 year, the scope of discovery will be more narrow during one of the Patent Office trials than it will be in the district court. Dollars and cents wise, this means that the administrative trials before the Patent Office should be cheaper than district court litigation. People are saying that district court litigation, we're in the millions. People are projecting that the cost for one of these administrative trials, probably $250,000 to $500,000. Now, that does seem like a lot of money, but it is cheaper compared to the district court litigation. Okay, let's advance for several slides, because that's all I think I'll tell you about the administrative trials today. We can go into details at another time or come up afterwards. The final final rules are going to come out for these administrative trials next Monday. Okay, Inventor's Oath Declaration. We're going to move now from provisions that are designed to prevent these bad patents or take them out of the system into building our 21st century patent office. The first provision we'll talk about is an inventor's oath or declaration. Now, any inventor who's filing a patent application has to file an oath or declaration before the office to declare themselves to be the inventor of of the claimed invention. So what the American Invents Act does is simplify the requirements for the inventor's oath declaration. Going forward, starting on September 16th of this year, an inventor will simply need to say, I believe myself to be an inventor of what's claimed in this patent application, and I authorized the filing. They no longer are going to have to say, I'm the first inventor, because we're not on this first to invent system. They are no longer going to have to identify their country of citizenship. And let's see, they're no longer going to have to say they filed this application without deceptive intent. That second bullet reflects requirements in today's law that the American Invents Act is getting rid of to simplify the oath and declaration. Next slide. Oh, yes, sir. Okay, so today you have to say you're an original inventor and you're a first inventor. So they've substituted out, because we're not going forward to judge whether you're first or not, you just have to say, I'm an inventor. And Congress chose to use the word original to mean I'm an inventor versus a non-inventor. So in essence, you're saying, I'm an inventor. Other questions? Okay. All right, now, let's say we can't find the inventor, and we need to file this patent application. So there's a way for, to even exist today, for instead of an oath or dec to be filed, you can file what's called a substitute statement in certain circumstances. They're listed for you in the first bullet. An example, the inventor has died. The inventor can't be found. The inventor is recalcitrant and refuses to sign the oath or declaration. In those instances, an entity, and the second bullet will tell you who, the legal representative, someone who has a proprietary interest, can file what's called a substitute statement. Substitute statement says, that guy over there is the inventor. I'm admitting he's the inventor, but he's not available, so I'm making the patent application for him. Next slide. The American Invents Act now will also allow these statements required for the inventor's oath or declaration, or the substitute statements, if we can't locate the inventor, to be included in an assignment document. This is going to streamline the amount of paper that has to come into the patent office. Going forward, the assignee can file a single sheet of paper reflecting the oath declaration statements plus the assignment statements. Today, 2 pieces of paper are required, the oath and dec and a separate assignment document. So now we're going to make it a little easier paper-wise. Next. Okay. Now, under our proposed rules, we wanted to have the oath declaration or substitute statements, assignment containing the oath dec or substitute statements, to be filed as early in the application process as possible, either with the application or within a short time thereafter. We received a lot of public feedback that says that's way too early. Oftentimes, we don't even know who the inventor is until we've engaged in prosecution and are at the point of allowance. Claim scope changes as you go through the application process. There are amendments made to the claims. Subject matter might be cut out through a restriction requirement and put in separate applications. We might delete some subject matter to avoid prior art. So the public told us we don't really know who the inventor is until the very end. So you will see that we've made a drastic modification in our proposed rules to allow for the oath declaration to come in at the end of the process after prosecution is virtually complete and an applicant has received a notice of allowability. At that point in time, the applicant will be able to know, here's what the property rights will cover. So we can figure out now who the inventor of those property rights are. Okay, next slide. Electronic filing incentive is a provision that went into effect last November. So what it says, what the provision does, is if you paper file your application, you have to pay an additional $400 fee. If you electronically file, you will not incur the $400 electronic filing incentive. So I would highly encourage those of you who are considering to file, do so electronically to avoid the $400 fee. Now you'll note it doesn't apply to design, plant, or provisionals. So for regular utility, which is what the bulk of you are probably filing, it will attach. It's easy to file electronically. On the last slide, I'll tell you where to go to find instructions, but it is not difficult, and you can save yourself some money. Okay, next slide. Now, the Patent Office acquired the authority to set fees for all of our services on September 16th of last year. But in order to be able to reset fees, we have to go through a rulemaking process. Additionally, Congress has told us how they want us to kind of proceed. They're saying to us that you have to set fees so that the aggregate revenue that you collect from all your service fees totals the aggregate cost to operate the agency. And that's what I'm trying to get at with the scales. So our revenue equals our expenditures. But within our scheme of 340 fees, we can set each individual fee at reasonable levels. This will allow us to incentivize or disincentivize certain behaviors. What we're doing is we've set some goals for ourselves in how we want to set these fees under the rubric of aggregate revenue equals aggregate expenditure. And that's the third bullet. We want to set fees in such a way that we collect enough money to address the backlog of applications, address pendency. We likewise want to build an operating reserve. Now, what do I mean by an operating reserve? I think of it as like a rainy day bank account where we put a little money into it, 3 months cost to operate the agency. That's $718 million. That the agency will include as part of its cost calculus so that if we experience fluctuations in the economy as we have in the past, we won't be in a situation to have to furlough examiners. We can go to our rainy day fund, take some money out, weather the turn in the economy, and then when it picks back up again, we can still continue to pursue the backlog, continue to pursue our pendency goals. And I'll tell you a little more on those goals in a moment. Okay, next slide. What I want to show you here is the backlog situation. And there's a mistake. A typo is in that last column, first row. Application backlog, milestone, it should be 615,000. Okay, so I had told you when we started right after the the American Invents Act went into effect, our backlog was at 670,000. We have dropped it to almost 630,000 today. We're making progress towards 330,000. But we have a ways yet to go, almost 300,000 applications. And mind you, we're dealing with 300,000 applications at the same time that we get 500,000 newly filed applications each year. So it's not all we're doing is spending the time on the backlog. We're managing the 500 that are coming in the door and contributing to the backlog. Okay, now pendency. There's two types of pendency. Pendency to a first office action and pendency to a final disposition. Here I'm showing you pendency to a first office action. When we started last September-ish, pendency to a first office action from the time we picked the case up took us 18 months. Right now, we're sitting about 16 months. Our goal for pendency to a first office action is 10 months in 2015. And then our goal to a final disposition is 20 months by 2016. Okay, so we want to take numbers down so that you get a determination on whether you have a patentable invention much faster. Okay, and I also mentioned how are we going to achieve a reduction in pendency, a reduction in the backlog. We're going to be hiring patent examiners. And how are we going to fuel the hirings? Through the fee setting process. We're going to use the money, the additional revenue we collect, to pay for the examiner's compensation and benefits. This year, we're going to hire 1,500 examiners. Next year, 1,500 examiners. So the third row shows you our March. Right now, early July, we're sitting about 860 examiners towards the 1,500 goal. And then we're hiring board judges. Our goal there is to hire 100 board judges this calendar year, and early July, we're sitting about 38. So we're moving towards our goals, but we still have a ways to go. Next slide. This slide is a visual depiction of the backlog. So where we started, taking us down to around 330, currently sitting at 630. Next slide. This slide shows you our reduction in pendency visually. You can see even going back further in time, pendency was much higher, 26 months. We're on a march towards 10 months. We currently sit about 16 months. Okay, next slide. Now I want to tell you, you know our goals. I want to talk about how we intend to set the 350-some fees. We have a plan in mind to set fees for filing, searching, examining, publishing, and issuing our patent application below what it actually costs to perform that service. We want to set these costs below because we want to encourage disclosure of technology, encourage people to file patent applications. That's what's going to fuel our economy and stimulate job creation. Now, somewhere along the way, though, we have to recoup the subsidy that we're giving. So on the back end, with maintenance fees, we set maintenance fees above cost. Maintenance fees are paid at 2.5, 7.5, and 11.5 years after a patent is granted. We believe at those points in time that you patent owners have ever-increasing amounts of information about the value of your invention. You know, are you commercially successful? Has somebody purchased your company? Have you made a mint off of it? So you know whether it's worth keeping that patent in force and in turn whether to pay the maintenance fee. So maintenance fees cost us, for any of them, only $1. We recoup the subsidy by setting them at well above $1. So that's how we balance the system. So on this slide for you, what you can see, and don't take the dollars literally, in February of this year, we put out a preliminary proposal on how we projected setting fees. We collected feedback. We've since changed that preliminary proposal. We're about to come out with our, what I'm going to call our actual proposal sometime in August. This slide shows you the preliminary proposal, so I'm cautioning you that the numbers are going to change, but we'll still be in the ballpark of these figures, so that you can see if we tally up file, search, exam, issue, and publication fees, and we compare today the current with what we're proposing to go towards, we're actually going to drop costs by about $500. So it's going to get cheaper for you on the front end to pursue a patent application going forward. Next slide. Now what I've done on this one is I've overlaid the first two maintenance fee payments onto the last slide. So the first maintenance fee payment is the green and the second one is the purple. I couldn't show the third one because of space. But you will see then on the back end, the costs are going to go up from current to proposed by about $800. That is where we are recouping that upfront subsidy. And the costs escalate, I'm going to be honest, even more if I were to overlay the third stage maintenance fee payment on those columns. So you can see that costs are going to go up overall. Front end costs are going to go down, back end costs are going to go up, and that's how we arrive at the overall increase. Okay? Next slide. Now, micro entity provision is going to offer some relief on fees for what I call a super small entity. for all fees associated with filing, searching, examining, issuing, appealing, and maintaining a patent application. The fees will be reduced by 75%. Now, this fee reduction by statute cannot take effect until the office engages in its fee-setting process that I just talked about. We project completing the fee-setting process in March of 2013. So this would mean that the micro-entity 75% discount would become effective in March of 2013. Now, who's going to be eligible? Who are these super small entities? There's two different definitions. The first one is based upon experience with the patent system and income. And it goes something like this. Okay, so you as the applicant have to qualify as a small entity. That means fewer than 500 employees. Second, you have to have an income that's less than $150,000. Third, you cannot have previously filed more than 4 patent applications. And then last, you cannot be obligated to assign or license your invention to a big entity. Okay, you meet those 4 requirements, you get the discount. Now, alternative, if you don't meet that definition, you might meet this one. You, the applicant, are either employed by an institution of higher education, or you are obligated to license or assign your invention to an institution of higher education. What is an institution of higher education? Well, that's a university. There is a specific definition, though. The Higher Education Act of 1965 has a multi-part definition to say who an institute of higher education can be. It's kind of a complicated definition. For me, the highlights are that the institution has to be physically located in the United States or one of its territories. Second, the institution has to either be not for profit or public. And those are the two that I want you to keep in mind. So an institution like MIT, a researcher employed by MIT is likely not going to qualify because MIT is private for profit. Okay? Next slide. Now the agency's issued some proposed rules on how you procedurally tell the patent office about your micro-entity status so you can get the 75% discount. We'll be coming out with our final rules probably January, February of next year before the March effective date. Next slide. Okay, I'm winding down. I want to tell you about some of the now programs that the American Invents Act institutes to help people file patent applications and work through the patent system. The first program is called Pro Bono, and it was effective last September 16th. What it does is it will connect an under-resourced independent inventor or small business with a patent attorney. And the patent attorney will file and prosecute the patent application for them. There is a one-time cost to the independent inventor or business of $1,000. The cost, that money is paid to a clearinghouse that does some preliminary evaluation of the patent application. Or I'm sorry, I should say the invention, to try to get the sense, is something potentially patentable here? If the invention is for a light bulb, the connection to the patent attorney will not likely be made. If the invention is for the next drug to treat cancer, the connection is most definitely going to be made. So we have to have some screening because there's a limited number of patent attorneys who are part of this program. So we can't do one-for-one referrals. The program is already working in Minneapolis and Denver, and we're expanding it nationwide. You can see the last bullet says, you know, we're going to open in California, New York, and the Washington, D.C. area, hopefully by the end of the year. Now, if someone is interested in participating in the program, you know, come up afterwards. I'm glad to take your card and connect you with the folks that are setting this program up. It's not being done exclusively by the Patent Office. We are working with bar organizations across the country to get this program set up. So I'll be glad to put you in touch with this. We have a pro bono committee that's working on establishing this program. Next slide. Okay, now there's another program called the Patent Ombudsman Program that will go into effect this September 16th, and it has two parts to it. The first part is what I call Inventor Assistance Center. What this does is it will provide information to somebody on the front end before they file a patent application to talk to them about filing, the steps, how to navigate the patent office, answer questions for them. The second part of the program is what I call the Patent Ombudsman's aspect to it. What that does is once an application is on file and it becomes jammed in the patent office system, you're not hearing from an examiner, maybe the application was lost, there is a specific individual that we call the ombudsman that you can contact. And this program, this aspect of it, is for anybody. It doesn't have to be an independent inventor or a small business. Anyone out there can call the ombudsman, and they will inquire about your application and give you a response in 10 business days, essentially freeing the application in the system, putting it back on track and towards either a patent grant or a final disposition. Okay, next slide. Last program is satellite offices. The America Invents Act requires the Patent Office to set up 3 satellite offices outside of our Alexandria campus by 2014. We opened our first patent office in Detroit, Michigan on July 13th. We are going to open additional offices in the other 3 locations on the slide: Dallas, Denver, and San Jose, California. Now, we'll roll them out in stages, but we at least have identified where the offices will be housed. What the plan is the offices will eventually be full service, but you have to walk before you run. So, early on, the offices are going to focus on limited numbers of technologies. For example, Detroit, we're harnessing the technology that resides in that area of the country, so we're focused on mechanical and electrical type inventions in Detroit for now. Eventually, we'll grow it to full service. Each office is targeted to employ 100 examiners and a handful of board judges. Right now, there are 20 board judges working in Detroit. So we will grow these offices. The other benefits to the offices is they will allow a regional place where inventors can come in and do interviews to examiners in any one of the other offices. So you can do video conferencing capabilities. You can also use the search facilities that are available at those offices. They are the same search facilities that we have in Alexandria at the headquarters. And incidentally, patent and trademark resource centers like the Arkansas State Library also have search capabilities that inventors can take advantage of. Next slide. Okay, so you have an overview of the Act. If you want to learn more, the Patent Office is doing a series of road shows where we are going to come to select cities across the United States in September. The slide shows you where we'll be. We're Minneapolis, Atlanta, Los Angeles, just to name 3 of the locations. We're spending a full day. You spent 2 hours with me. We're going to spend from 10:30 to 5 o'clock talking about all the details of these provisions that go into effect on September 16th. First inventor to file and fees. You'll learn everything you wanted to know and then some about these provisions. So they're free, open to the public, anyone can come. And I would encourage you, I know we're not coming back to Little Rock, but if you happen to find yourself in one of these cities or have an interest, you can also watch them on the web. We will have the first 3, Minneapolis, Alexandria, and Los Angeles webcast, and we're recording them so you can watch them after the fact in October, November, December on the website. Next slide. So I want to leave you with some information where you can go to find details about what I've talked about today. The first bullet is what I call the AIA microsite. The web address is www.uspto.gov/America Invents Act, all one word. This is a special website that the Patent Office has created to house all of our information about the America Invents Act. It's one-stop shopping. There are questions and answers. There's regular stories posted to talk about the provisions. We announce all of our speaking engagements on there. We post the proposed rules, the final rules, our guidance documents, anything you want to know. So I would encourage you to look on the microsite if you have questions. We're about to open a hotline telephone number that you can use to call in with questions. We'll announce that, roll it out on the microsite. So anything you want to know, the microsite is the best place for you to start and then grow from there. You have my contact information on your slide set. You can always call me, email me. I'm glad to help you with anything I can, America Invents Act or otherwise about the patent system. And I'm happy for your questions. And you've been quiet for the second half. So do you have questions for me or points of conversation that you would like to bring up?
Can you talk about the income limitations for the microstatus one more time? I was getting confused between when you said income limitations. Was that for the inventor applicant or
Yes.
the corporate entity perhaps?
Okay, yeah, okay, I'm sorry, I don't mean to confuse. So for the question has to do about the micro entity and the definitions to qualify. There's two definitions. One definition is keyed off income and patent office experience with filings. For that definition, the applicant cannot make more than $150,000 to be able to qualify for a micro entity discount. The separate definition deals with employment at a higher education institution. There's no income restriction under that definition. And now, you raise an interesting question because when I say the applicant can't make more than $150,000, we mean that to be each individual inventor named on a patent application. So if an application has 2 inventors, each one of them will have to be below $150,000 in income for that inventive entity to get the 75% discount. If one is below 150 and the other is above 150, then that inventive entity will not qualify for the discount. Does that make sense?
Yes, that makes sense. I'm thinking of the case where there's a startup tech company, so neither of those is tied to the entity itself. If let's say there's 4 PhDs all employed by the same startup entity, those limitations are not attached to the entity, only to the individual applicants.
Correct.
Right.
Only to the individual applicants, not to the startup company per se.
And just a quick reminder on your questions, we are live streaming, and our audience that's listening, the only way they hear what your question is by speaking into this microphone. So that's why I'm running around with a microphone. It's not to be a nuisance. It's just so whoever is listening in, watching in, can hear your question. Any other questions?
Other questions or comments? Now, if you're shy, I'll stick around, but your colleagues might benefit from your questions. Any remaining remarks? Yes, sir.
If we want to look at the items in the bibliography, we actually have to go to the CFRs and whatnot that were listed. Is that?
So if you want to find, would you please, yes, thank you. Okay, if you want to find any of the items that I'm recommending for further reading, yes, you could go to the CFRs or the Federal Register documents. But if you go to the microsite, the first bullet, I have all of those documents posted there. And I actually put the titles in plain English rather than what the Federal Register titled them. Yeah, so that's the place to go to look for the documents. Other questions, comments? Oh, yes, sir.
Let me go ahead and sit down real quick. This is like kind of like off the record, but what do you think about the Apple controversy with their patent lawsuits that they have against Samsung with this rectangle shape that they are using towards their phones? They're saying that these people are taking their idea of a rectangle on the phone. What do you think about that?
So I have a confession for you. I live, breathe, and die by the AIA, and my head has been swimming in AIA. I'm embarrassed to say I haven't even followed the smartphone wars, and maybe that's a good thing. I don't know, but I have no opinion that I can share because I know very little about that litigation. I know it's pretty intense and feverish, and it's all over the media, but I have to confess, I really don't know anything about the scope of the lawsuits, so I have no opinion. Do you have an opinion that you'd like to?
My thing is, okay, I'm gonna bring out my phone. My phone I have is an Android, it's an HTC, and you notice that most phones that are smartphones are typically rectangular shape because that's the psychology of how people are used or accustomed to using a phone, a smartphone. So it's kind of like, in my opinion, it's frivolous. You know, it's petty. I feel like you're trying to make an issue out of something that you have claimed to have invented, but yet it's been around before they even started making smartphones. That's how I see it.
Yeah, I was wondering if you could go into a little more detail about exactly what pendency was. Was that the time frame when it actually got into the examiner's hands until a decision was made, or when the application was submitted?
So pendency has to do with the amount of time it takes from when the examiner picks up the application until and it goes on to the examiner's docket until the examiner issues a first office action. That's the first type of pendency. Presently, that pendency, from the time it gets to the examiner's docket till the first office action, 16 months. We want to take that pendency to 10 months. The second kind of pendency is the amount of time from when the examiner gets the application on their docket until they reach a final determination, either patentable or not patentable. Currently, that amount of time is about 34 months. We want to take that time to 20 months by 2016. Now, I didn't tell you how long it takes from when you filed your application until it gets on the examiner's docket, right? That period of time is roughly, depending on the technology, 3 years, okay? That's roughly 3 years. But then when we pick it up, you know, right now it's about 3 more years until you get a final decision, roughly. So this upfront pendency of how long it takes until it gets onto the examiner's docket, that's dictated by the backlog and by incoming filings.
You can circumvent that first 3 years by getting the fast track.
Yes.
Okay.
So that was my point. Earlier, the first topic I covered is prioritized exam. You can circumvent that first 3 years by going through prioritized exam. And then in actuality, the pendency, the second form of pendency to a final disposition, for prioritized exam, that's currently about 5 months. In 2 months, you get the first office action. And in 5 months, you get the final disposition. So the numbers are really, really good in prioritized exam.
So 6 months versus 6 years, pretty much.
In a nutshell.
Okay.
In a nutshell. Now, I expect that, you know, the 2 months and the 5 months are probably going to go up a little bit if we get more cases for prioritized exam. Remember, right now we've only had 5,000. But if we get 10,000, it's going to go up. You've got to know that. But it's going to go up nowhere near 10 months and 36 months. So it still will be a better for you if you need a patent faster. Oh, I should have mentioned too, when I talked about the fee setting process, we're evaluating all those fees. I didn't say something about prioritized exam, but when we come out in August with our proposal, you will see that we are proposing to reduce the cost of prioritized exam. I think it's something close to 20%. So 4,800 goes down to close to 4,000, 2,400 goes down close to 2,000. Still going to have to pay for it. And really, you want people to pay for it because if it was free, everybody would do prioritized exam, and then no one would get a fast exam because the backlog would just shift from regular docket to prioritized exam, and it will become meaningless. So there is a justification and a need to have a fee. It's our job to figure out what the right level for the fee is. Any other remaining comments or questions? No? Well, I thank you very much for your attention, and I appreciate you staying here through the whole afternoon with me. And just let me know if you have any more comments. You have my contact information.